will now call 123-650, State of Kansas versus Carol Sue Burris.
May it please the court, Casper Shire appears for Carol Burris from the Kansas Appellate Defender Office. Your Honor, could I please have 3 minutes for rebuttal?
3 minutes is granted.
Thank you. Carol Burris has been convicted of and punished for very serious crimes based on something that she did not do as opposed to something that she did do. Carol's husband, Michael, passed away after a years-long battle with health conditions, including heart disease, lung disease, diabetes, hypertension, and dementia. During the final months of his life, Michael was confined to his home in New Strawn, Kansas, where Carol cared for him. Following an investigation, agents of the state formed the opinion that Carol did not do enough to care for Michael during his extended illness, and Carol found herself charged not only with mistreatment of a dependent adult, but with reckless second-degree murder. A jury later convicted on those charges. First and foremost, I am here today to contest the murder conviction. The foundation of the state's case here, again, is something that Carol did not do as opposed to something that she did. And the reckless second statute simply does not criminalize omissions in that way. The state should not be allowed to make difficult end-of-life decisions crimes, especially murder. Furthermore, even if assuming that
these were not, I'm not sure it helps your argument to characterize what happened as difficult end-of-life decisions.
I think Carol was facing a difficult situation here. And it's a situation that a lot of us have faced in some way or another. You know, Carol had called for help before. Michael had gone to the hospital. He was there for a little bit. He chose to go back home and he was sent back home, and everybody was right back where they started. It's not at all clear that, you know, calling for an ambulance to come and check on Michael was going to be anything more than a short-term fix, very much like it was the first 2 times. And furthermore, even assuming that an omission of care can support these convictions, there was nothing in either the reckless second statute or the mistreatment statute that put Carol on legal notice that she had a legal obligation to provide some different level of care to Michael. On top of that, inflammatory closing argument denied Carol a fair trial on these charges. And for all of those reasons, we are asking this court to reverse both the Court of Appeals and her convictions.
What significance, if any, does it have that she did on occasion actively prevent help from occurring? She turned people away. She hung up the phone. Someone called.
As to the murder charge, I don't think it has any significance, Your Honor, because we're still talking about the choice not to provide a particular level of care. We're still talking about something she didn't do as opposed to something that she did. And if this court is going to say that choices like that, choices not to provide a particular level of care, can be acts for the purposes of supporting a murder conviction, I think that puts us on a very slippery slope.
What do you think about KSA 21-5201B, which is the statute defining an act, in the context of the argument you're just now making, when it talks about an act can be an omission if the statute uses the word provides or provides that such person had a duty to perform the act.
Right, and I think, Your Honor,
So is that what we're arguing? Are we arguing about the existence of a duty to act, or are we? Because I think everyone agrees that the state prosecuted based on an omission.
right. And I think we're arguing about both, because I think there's a difference between the reckless second statute and the mistreatment statute. The mistreatment statute does criminalize omissions. There's a
Right.
textual difference there that I think
Let's
makes a
just
big.
focus for purpose of my question, at least on the second-degree murder statute,
Okay,
which does require an act.
yes,
And when we ask the question, what is an act? Can an omission be an act? We look to 5201B.
right,
Would you agree with that?
yes,
And 5201B says an omission cannot be an act unless such person has a duty to perform the act. So
okay.
that's my question. Is that what we're arguing about? Whether or not your client had a duty to perform an act and failed in that duty?
Well, I think we are arguing about that, Your Honor, but I think as a threshold question, I want to dig down on what is actually in 5201B, because it says a person who omits to perform an act does not commit a crime unless a law provides that the omission is an offense or otherwise provides that such person has a duty to perform the act. So the law does not put a duty, and especially not, I mean, arguably we're.
So you would ask us to construe 5201B to be referring to the criminal elements of the charged crime,
Yes,
as opposed to the law generally.
yes,
Okay.
yes, Your Honor. And that's why I think there's a threshold question for the murder conviction that we don't have. And all the secondary questions was there a duty here? I think those are present for both, but I think there's a first hurdle we need to get over for the murder conviction.
Textually, your interpretation of 5201B really comes down to it says a law, as opposed to maybe the law more generally.
Well-
How do you, I guess, what's the link back to the actual offense being charged to create, to give rise to that duty, as opposed to other sources of law,
Well,
at least textually under this subsection?
if we're not looking back to the offense that's actually being charged, then I guess I have no idea what we're looking to. Are we looking to tort law? Because tort law creates all kinds of duties and all kinds of people. And I don't think we can be looking that far. I think we have to stay focused on the crimes that Carol was actually convicted of.
Yeah, I understand that argument, but is there a textual basis for that conclusion under 5201B? Or are you suggesting there's ambiguity and or due process or some other notion requires us to construe it that way? Or
I never viewed the statute as ambiguous. I always viewed it as looking back to the crime that the accused is actually.
charged?
I mean, let's imagine that she was charged only with reckless second here, right? And not with mistreatment of a dependent adult. Why would we be looking to mistreatment of a dependent adult to determine whether or not there's a duty when all she's charged with, when the only law that's applicable is the reckless second statute? And I guess to the extent that there is any ambiguity there, of course, my argument is that needs to be resolved in Carol's favor.
And I guess I wondered whether the fact that it said a law as opposed to the law might run counter to that interpretation. A law being just more generally, there a law out there that gives rise to a duty to act.
And if, I mean,
And to that end, there's case law in Kansas that, absent a special relationship, which I think here we do have a special relationship, a husband and a wife, which I think is different, but even absent a special relationship, in State v. Wilson, we held that, once a person steps into the role of a caregiver, such that others are discouraged or precluded from filling that role, that person does have a duty.
And I understand that argument as applied to mistreatment. I don't agree with it as applied to the facts of this case, because Carol was never put on notice that she had a duty of care here, not by any law. But I do not agree with it as applied. I do not think it applies to reckless second-degree murder.
Okay, so if, I just I don't understand that, especially, I could, maybe if it was just failure to take care of somebody, but, maybe you could say this wasn't an omission, this was an affirmative act, is that she affirmatively did not let other people care for her husband.
She made choices, Your Honor, not to provide a particular level of care. And
that's an affirmative act.
it is not, Your Honor. I don't believe it is. It's a choice not to provide a particular level of care. And
I am not going to let you talk to my husband. I am not going to let you into this house.
yes, those are choices not to provide a particular level of care. And
So what if it was a child?
Your Honor, if we were talking about, I don't have the child neglect statutes in front of me, but my assumption is that they would criminalize omissions of care very much like mistreatment of a dependent adult does.
So you could go ahead and charge child abuse, but not murder in the second degree if a child died.
Based on an omission, yes, Your Honor. I do not believe you can criminalize an omission as murder based on 5201B. That is my position.
Okay, so let's talk about the duty. Duty to a child, or this isn't even a common law marriage. This is a 40+ year marriage where the parties undertook, push aside the religious aspect, but, they had they have a contract with the state, right? Sanctioned by the state that they were married. You don't think that somehow creates some kind of duty under the common law?
It's not in the statute, Your Honor, and the Kansas Constitution did away with common law and replaced it with statutory law.
Okay,
That-
but let's say that you lose on the, as Justice Wall is saying, that it's not the law, that it's not the second degree murder statute, but it's a law. Okay,
Okay,
all right, which State v. Wilson would count as a law, that once you undertake a duty, which she clearly undertook, and prevent other people from fulfilling that duty, once you stop, I guess, then that doesn't fit?
no, the law that we're looking at, mistreatment of a dependent adult, lays out who a dependent adult is, but it does not lay out who has a duty of care. It does not say that a spouse has a duty of care. It does not do that. She was not on notice that she had a duty of care, and she can't be punished for it.
What about when she took the phone away from him? That would have allowed him to keep some ability to care for himself by calling for other help. The duty of control over his care when she did that, aside from the marriage?
No, Your Honor, she did not assume the law placed no duty on her here.
Okay, so Mr. Shire, I guess what you're saying is that under Kansas law, no matter what happens, the only thing you could charge her with is mistreatment of an adult, of a dependent adult. No one under any circumstance ever could be charged with second-degree murder, ever.
Not with second-degree murder, not on the, not based on an omission, Your Honor. The only way that I can think of to get to a murder conviction via an omission would be potentially through felony murder, but that's not this case. They
So
charged her
even,
with reckless
yeah.
second.
Under the failure to care for a dependent adult, is there a duty in there? That statute?
There's a duty, but the statute does not say who the duty falls on. The statute does not designate who is obligated to perform care. And that's the problem with the statute.
Wait, so how can she be charged under that then?
We don't think she should have been, Your Honor. That's the
Well-
second part of our argument.
Okay, so who can be charged under that? Anybody? Or is that just another situation where nobody can be charged under that? Oh, unless it's like somebody who's getting paid.
I mean, I think legislative clarity would be a big help.
But
I
it's your
think-
position that nobody who is caring for a dependent adult, unless it is their job and they're getting paid for it, could ever be charged.
I'm saying if this court is going to say that there's a class of people that have a duty, it's too late to put that duty on Carol. She was not on notice at the time that these things happened, that there was a legal duty.
But
to
under
care
State
for
v.
each other.
Wilson, we said that someone who wasn't on notice.
And I don't
mean, to
know,
me, it's, I mean, you're on notice, you're married.
and I do not believe that marriage creates a legal duty of lifelong medical care, Your Honor. I'm unaware of,
Can I follow up on that? Do you think, are you arguing that the common law did not impose a special duty of care on spouses due to the relationship?
that it did not.
Yeah, is that your argument that the common law did not?
To be perfectly honest, I don't know whether the common law,
So your argument is just the common law is irrelevant.
yes, I
And
think
that's what I want to explore. Why is that?
because the duty needs to be described in the statute.
Why?
Because 5201B says that,
I mean, common law is still law, right?
but where the Constitution abrogates common law and replaces it with statutes, I don't,
Where it does, right. I mean, we have long history in our case law of saying that the common law of England's the basis of the law in this state, and unless it's modified by constitution, statute, or judicial decision, it continues to remain the law. And that, I'm reading a quote from a Kansas Supreme Court decision. So has that special duty of care been modified? Can you point to a modification somewhere?
what I can point to, Your Honor, is legislative silence. When the legislature wants to create a duty like that, when they want to criminalize an omission, they know how to do it and they have done it. And we don't see it in the statute, Your Honor. I think we have to take the silence at face value. And I apologize. I recognize that I'm well over time. Unless this court has further questions, I'll save any further thoughts for rebuttal. Thank you.
Mr. Obermeyer?
May it please the court. The state of Kansas appears by Stephen J. Obermeyer, an assistant solicitor general. I disagree that the legislature has to pass a statute to say that you can starve somebody to death, omit to feed them if they rely on you for care under the language in, I think, the Wilson case that you referenced. And that's a civil matter. It's not a crime. I think the language of the reckless second-degree murder statute is broad enough to include reckless conduct. And that conduct is realizing certain circumstances and not acting in those circumstances, in response to those circumstances. And the statute is 215202J. A person acts recklessly when such person consciously disregards a substantial and unjustifiable risk that circumstances exist or that a result will follow, and such disregard constitutes a gross deviation from the standard of care which a reasonable person would exercise in the situation. Jury was instructed on that. Those were the arguments made to the jury by the state. And this is more than just an omission case. There's plenty of evidence. Justice Standridge, I think you mentioned one thing, running people off when the investigator shows up. She says, we're tired of people coming here, leave. When the person who transports Michael back to the house, she's like, be quiet, don't upset the dogs, put him in that room. And then the EMT started to discuss instructions, and she starts talking over him. And the hospital calls and want to talk to him, and she doesn't let the EMT talk to the hospital. She's not, and if you look at her 2.5-hour video, she's not saying, I didn't do anything, I didn't have to do anything. She's saying, I was a 24/7 caretaker of my husband of 45 years. I did everything I could. He was fine up until yesterday. He ate 4 times yesterday. And today he just has a sinus thing going on. That's the only reason I called. And gee, this is the Spanish Inquisition. I wish I hadn't called now that, anytime I call you accuse me of being a bad caregiver. This is not entirely about omission. And during one of your questions, Justice Stiegel, I looked up what does the legislature say the definition of an act is in 215111. Subsection A says an act includes a failure or omission to take action. She decided, I'm not going to feed him. It costs money to have an ambulance come out here. These are things that she's thinking about, and she explains to the detective during the execution of the search warrant why she didn't do certain things. So this is not an omission case that this was just foisted on her and she had nothing to do with it. And I would contrast that with the Robinson case, where it was a child endangerment case where the 2 people are actually living in the house with the child who's being abused. I think one of the defendants was the paternal aunt, and the court, this is back in 1999, says, an omission isn't enough. You have to actually have a special relationship to have a duty to aid or care for another person. And one of the defendants in that case did not have, well, neither of them had the relationship. And so for that reason, there was not a duty. So I think the Court of Appeals was right in citing Robinson and discussing a duty, and whether it's common law or marital or not, she assumed it. She told people she was taking care of Michael, and she ran work people off when they tried to offer to move in with the sister in Oskaloosa, come live with me. She says no. Strapping a urinal onto a person is not an omission. I think that's an act. So there's
Repeat that again. I was just repeat what you said.
Strapping a urinal onto a person is not an omission. That is an act. And so there are several actions. And if you look at the Davidson case, the argument in Davidson was she just, didn't contain the dog. She, didn't keep the dogs in the fence. And the court says, no, this is more than just not keeping the dog. She disregarded advice from people on how to keep the dogs separate. Don't let them become pack animals. Secure your fence so they can't get out. There were several warnings where the dogs got out and were basically menaces to the neighborhood. Here she said home health is unnecessary because she plans to take care of him herself. And I mean, the Court of Appeals opinion and the briefs are full of facts to support recklessness by Carol in this case. She slammed the door in the face of one of the investigators. So I think it's more than that. I think the language of the statute defining reckless would cover what happened in this case. And that was what the jury found. And a lot of it was the fact that she had these dogs, and she told the investigator, the dogs are my family. I've had them for 12 years. And they said, well, what about your husband? And she's like, well, what is this, the Spanish Inquisition? So she took action. She isolated her husband, who had dementia, who couldn't help for himself, who couldn't call out, and just decided not to feed him. And he went from 250 pounds on his driver's license in 2012 to maybe 125, I think. The autopsy included his weight with the bag and everything. So I think he was actually less than that. But to ignore that is reckless act. And then also there was one of the exhibits documents all of the decubitus ulcers that he had. And some of those had gone not from level 1 to level 4, but they were necrotic. So would is that a gross deviation from the standard of care a reasonable person would use in the same situation to not just make a call? She didn't have to be Clara Barton and help her husband. She just had to call. And she didn't. So I think for those reasons that there was sufficient evidence to support her reckless second-degree murder conviction. Unless the court has any other questions about the other issues, I'll just rely on the briefing and supplemental briefing in this case. There being no questions, I would ask you to affirm the jury's verdict in the Court of Appeals opinion. Thank you.
Sure.
Thank you, Your Honor. This court has said, and I'm quoting from Dinkle, that every crime requires a voluntary act as part of the actus reus. So it's very important that this court not conflate the culpable mental state of recklessness with the voluntary act requirement, because those are two different things. This case is still about something Carol didn't do as opposed to something that she did. And I think, as I started to mention before, once we get into the business of, determining that not providing a particular level of care is an act that can support a second-degree murder conviction, we are on an incredibly slippery slope.
Okay, I want to understand your argument a little bit more, because I'm having some kind of disconnect here. Okay, so when we go to the mistreatment, okay, you're talking about an act, and we can't have an act unless there's a duty. I mean, an omission can't be an act or unless there's a duty. Okay, so you go to the mistreatment statute, and mistreatment of a dependent adult is knowingly committing one or more of the following acts. And under 3, omission of treatment necessary to maintain the physical health of a dependent adult. Okay? So number one, would you agree that the husband was a dependent adult?
There was certainly evidence to support that
Okay.
at trial.
So omission of treatment is listed in a law, right? I mean, there's a duty here. And the duty is on the person who the dependent adult is dependent upon, correct?
I don't think the law says who the duty is on, Your Honor.
Well, who else could it be? What's the definition of a dependent adult? It has to be the person upon which the dependent adult is dependent. I mean, isn't that what it would be?
I don't think that's specified in the statute, Your Honor.
Who else
There-
could it be?
Well,
So So a dependent adult that lives in Oskaloosa, am I responsible for, I mean, that person isn't, that person isn't dependent on me.
to be honest, Your Honor, I think there are a number of people across the spectrum here that could have stepped in to do more for Michael. That might include doctors, that might include,
But she didn't allow those people to come in.
well, Your Honor, those people there are a number of choices here that were made. Some of them are Carol's and some of them are not, that led to a bad outcome here, right?
What choices of other people were made?
Well, there's, at least one, state agency out there that does a report on this situation, files it, and then sits on it, doesn't follow up on it. It just sits there.
So you're saying because your client abused and mistreated her husband, that's the fault of the state agency?
Your Honor, I'm saying there was a much greater effort here to investigate and to villainize Carol than there was to help her. People were knocking on her door to accuse her of wrongdoing and not to provide meals, not to provide services. That's not what was happening. I think this is a failure of the system, and Carol became the scapegoat for that failure.
Can I ask you, under your argument that the statute in question, the second-degree murder statute, doesn't criminalize an omission, how do you reconcile the circumstances manifesting extreme indifference? Because indifference suggests to me omission, but does that go to the mens rea rather than the actus reus of the statute?
Yes, Your Honor, that's our argument.
And that's the distinction.
And that's one of the primary complaints that we had with the Court of Appeals argument, is that it really folded those together and said that an omission is assumed within recklessness. Well, even if that's the case, we still have a separate voluntary act requirement that needs to be met.
Well, why can't an omission be a voluntary act? I mean, that's,
And-
Dinkle focused on willed bodily movement and was pretty narrow in its holding. And it didn't discuss other types of
Right.
examples, but I don't see why an omission isn't a voluntary act.
And that's where I would point this court back to 5201B, which says an omission is not a crime unless a law makes it so. And the reckless second statute does not.
I want to ask a question, if I may. Reus, the actus reus is different from the duty, correct?
Yes.
So in a prior case, State versus Bolsey Sand, a daycare provider was convicted of involuntary manslaughter. And one of the things that were alleged to be reckless was her failure to properly care for a toddler. And so he was on a bed and the conviction for involuntary manslaughter, reckless, was upheld. Can you distinguish that case from this one with regard to the actus reus element?
Well, first I'll say I'm not familiar with that case. I don't know how old it is. Okay. I don't know if the voluntary act requirement argument was made in that case. I don't think many people at all were making it before Dinkle, to be honest with you, Your Honor. We have presented it here. I don't know whether it was presented in that case or not, and to be honest with you, Your Honor, I don't know the facts of that case well enough to try and distinguish it from this one.
Other questions?
Thank you, Your Honor.
Thank you to both counsel. We will take this appeal under advisement.